Does the Sixth Amendment's right to counsel in criminal cases extend to felony defendants in state courts? Clarence Earl Gideon faced charges of felony breaking and entering in a Florida state court. When he appeared in court without legal representation, Gideon made a request for the court to assign an attorney to him. However, under Florida state law, legal counsel could only be appointed for defendants in cases involving the death penalty, and therefore the trial court declined to provide one. Consequently, Gideon had to represent himself during the trial, which resulted in a guilty verdict and a 5-year prison sentence. Gideon later filed a habeas corpus petition within the Florida Supreme Court, contending that the trial's court decision violated his constitutional right to legal counsel. The Florida Supreme Court, however, rejected his habeas corpus petition. Gideon appealed to the United States Supreme Court in a suit against the Secretary of the Florida Department of Corrections, H.G. Cochran. Cochran retired and was replaced by Louis L. Wainwright before the Supreme Court heard the case. Question 1. What did Gideon file to the Florida Supreme Court? What was their response?
While in prison, knowing he was falsely imprisoned, Earl Gideon would go on to immerse himself in the prison library studying law. In January 1962, he composed a heartfelt letter to the United States Supreme Court, urgently appealing for them to consider his case. His efforts were not in vain, as the Supreme Court accepted it. Thus, Gideon V. Wainwright was set into motion, with the Supreme Court appointed attorney Abe Fortas representing Gideon. Fortas argued that a fair trial in a criminal case couldn't be ensured without a legal counsel, also known as an attorney. He emphasized that individuals lacking legal expertise were ill-equipped to defend themselves in a court of law. The central argument revolves around the Sixth Amendment's crucial right to an attorney in criminal cases. Question 2. Which specific constitutional rights outlined in the Sixth Amendment were allegedly violated in the case of Gideon v. Wainwright?
Chief Justice Earl Warren oversaw this case. Based on a prior case that occurred in 1942, which was Betts v. Brady, the opposing side maintained that refusing people who were charged with felonies did not really violate the 14th Amendment, specifically being the Due Process Clause, stating that the amendment does not embody, quote, an inexorable command that no trial for any offense or in any court can be fairly conducted in justice accorded a defendant who is not represented by counsel. The Betts v. Brady case then said that counsel can only be provided under special circumstances. Furthermore, Florida law, which applied to Gideon since he was a native to the state, stated that only lawyers or counsel can be provided to the indignant only when they have committed a capital offense rather than a felony. Based on Florida law, when is the defendant granted a lawyer, assuming that they cannot afford one? How does this apply to Gideon's case? The entire court had essentially sided with Gideon's case based on a unanimous decision of 9-0. On the behalf of the other members of the Supreme Court, Justice Hugo Black had authored a unanimous opinion that basically said that the Sixth Amendment should uphold or represent the fundamental right of being granted counsel for all criminal prosecutions, and therefore the states must follow this constitutional right through the use of the 14th Amendment.
What was the final ruling decision made by the court? What did Hugo Black state in his opinion?
The significance of Gideon v. Wainwright is similar to Earl Warren's case that preceded it, because, like the others, this case served to incorporate the Bill of Rights into the states. In this case, it was the Sixth Amendment, which in addition to the right to an attorney, includes a speedy trial and an unbiased jury. As stated, before Gideon v. Wainwright, the state of Florida did not guarantee a public defender to people accused of crimes. It is also right to note that there are only 5 states, including Florida, do not guarantee legal counsel to the poor during this time. Which brings me to another point of significance. Earl Gideon was homeless, and he couldn't afford an attorney. This boils down to a core value in this country, but more specifically the more liberal side of this country, where justice and happiness should not only be to those with the most money, but instead be equal no matter somebody's economic status. And believe it or not, Gideon was given another trial where he was appointed a local lawyer and ended up getting acquitted of his 5-year sentence, and he was freed from prison.